is working. A law change in 2014 introduced mandatory family dispute resolution for separating couples, designed to settle disputes before they reach the family court. 6 years on, Justice Ministry figures show only 2,000 mediations took place last year, despite nearly 6,500 applications. At the same time, more couples bypassed mediation, applying directly to the family court to resolve their disputes, nearly 7,000. Auckland Master of Laws student Nurit Zubery's thesis research has revealed that divorce has startlingly negative impacts on men, in particular their mental health. She says family mediation is underutilised, but the men she spoke to for her research reported feeling disadvantaged and disempowered by the process. Nurit Zubery is in our Auckland studio, along with her master's supervisor, Auckland University Professor of Law, Mark Henaghan. Kia ora kōrua, welcome.
Kia ora, Kathryn.
Kia ora, Kathryn.
Mark, can we start with you just to get an overview of the endless changes to this system? 2014 brought in some significant changes, like mandatory mediation, and also there were some changes around the roles of lawyers and when they were and weren't allowed in the system. Can we talk first about what the data is telling us about mediation? Why this huge gap between the applications and the numbers happening?
Well, first of all, when the changes happened, Kathryn, taking the lawyers out meant that the only way you could get a lawyer was if you applied as an urgent matter ex parte without notice to the court. And you'll probably be aware the figures of applications on notice, without notice, in other words, urgent matters, went up 87%. So people decided that rather than go to mediation, because if you go to an ex parte application, you don't have to go to mediation, and you get a lawyer. And so a lot of people went straight down that track. So it did divert a lot of people away, perhaps, from mediation, and perhaps start off in the worst possible way with an application without notice alleging things with regard to the other party's behaviour.
Can we just pause on that, Mark, because it is a startling figure, isn't it? And we know this whole system got reviewed a year or two ago, and I thought the figures were even worse. I thought it went from something like 30% to 70% going straight to a without notice application.
Yes, it was. It's very, very high. And that, of course, causes a really bad way to start off any kind of conversation about the placement of your children, because straight away all you get is something in the post. Your side hasn't been heard. Allegations have been made by the other side about your bad parenting or whatever you've done, and that really sends things down a bad track. But, of course, and many of the applications, the judges didn't always hear them without notice. The judge would sometimes say, look, we're going to actually hear the other side before we make a decision. But it already had started down a track where they could have a lawyer. And a lot of people do want a lawyer in these situations.
So looking at the 2018, or looking at the 2019-2020 figure, 5,320 without notice applications. The other kind's the on-notice application. What's that?
Well, on notice under the 2014 reforms, unless it was an urgent matter, you would actually, as long as you've been to mediation or you had a reason not to go to mediation, we'll come back to that shortly, you had to do it yourself, so that people had to self-represent, basically, which, of course, in perhaps the most difficult decision people ever make. I mean, when people are in divorce, their emotions are very, very high. Losing their children or not having contact with their children is the major issue in their life. And to go in and kind of represent yourself and put yourself forward is a big ask.
So we ended up with 6,848 to be precise, last year, bypassing mediation and going into this system. Go straight to the court, essentially. And do we know what percentage of separations that represents? Because the old figure used to be only around 5% going to the family court. Is it now far higher?
It probably is higher. It's very hard to get accurate figures at the moment, actually, as to what the percentage that do go to court. I think there are a number of different reasons why people... One of them is that they want to apply without notice so they can have a lawyer. There are other reasons as well. Obviously, a lot of relationships, very sadly, Kathryn, in our society, there are elements of power and control and violence going on, so parties don't feel comfortable going into a process of mediation with someone they don't feel comfortable with. People can decline for whatever reason. There's no reason for them not to decline. They normally have to have some sort of reason, like I don't feel comfortable sitting in the room with this person, and then they get a certificate to say they can go to court without having gone to mediation. So while it's mandatory, there are a lot of exceptions to it. So people get that sort of fear of going along saying, I'm not ready yet, I'm in a state where I'm going to sit with a stranger, I don't know who the mediator is going to be, I'm going to have to talk about things I don't feel comfortable on my own, I just don't feel ready for that.
You see, that was the other part of the changes post-2014. Wasn't there a counselling process pre-mediation that got cut back? The number of paid visits got cut back.
Yeah, that was a fantastic system. Basically what happened was that everywhere in the family court throughout New Zealand, you had these wonderful counselling coordinators. These were very experienced counsellors who would meet with each party separately. So they wouldn't meet together. They would talk it through with them, see how they felt, see where they were at, and then they would work out what was the best form of counselling, who were the best kind of counsellors to talk through some of the issues. And they would have at least 6 and sometimes up to 10 sessions paid for by the state, and then they would move on to, if they felt comfortable, to a mediation session with a judge and with their lawyers present. So it was a much more gentle introduction to the whole process.
For those who've stuck with it and gone through mediation, only 2,000 as we said, what were the results like? Most actually got to full or partial agreement, yeah?
Yes, well, I suppose these are the parties that do feel comfortable sitting in a room discussing it with a mediator, and felt ready to do that. So basically, almost voting by their feet, they felt ready to go into that process. The others, when they pulled out, don't feel ready to go into that process. So by definition, those who do go into it are going to try and get some result.
I'm presuming this is only adding to backlogs in the family court. It's hard to see how it could be otherwise.
It is. I mean, I haven't spoken to a family law recently who isn't run off their feet. They're absolutely flat out.
So how does the old system compare, the new system rather, compare with the old, Mark? Would you say it has been a big step backwards?
I'd say it was a big step backwards, and that was argued by family court judges, family court lawyers, many people, and also it came out very strongly in the wonderful review that �W𝐮𝐬𝐭 led. That was a fantastic review. People just didn't feel they had time to be heard properly, didn't feel they were understood, and often the focus wasn't on children.
2 years ago, she reported. Has there been any change since?
Yes, there has been one change. It came through last year where now that in ordinary matters, in other words, you don't have to make an ex parte application to get a lawyer, so you can go into court with a lawyer, even if it's just an ordinary application. So that's been one important change.
All right. Nurit, can we bring you in, please? You are a lawyer by profession, now qualified mediator and studying for your Masters of Law at Auckland University. What was the research that you undertook and why?
I took the research wanting to listen to how men feel and after they've gone through mediation. I've done that because there's hardly any research that was done either in New Zealand and even around the world. The quantity of research about men is very limited. When they do in New Zealand, they've done 3 big sort of studies about the family justice system, and it was done through questionnaires and it was done through people responding to requests. And in these studies, there was around 85% of respondents were women. So men are not easily, they don't easily respond to things naturally. And there was a need to see how men feel.
Were you reluctant at first? As you said, we know lots of the dynamics around family violence, for example, at one extreme end of separation, or not necessarily extreme end of separation, but there's been a lot of research done because of concerns about that dynamic. Mark alluded to the power and control dynamics, but has a lot of this focused on women's experience?
I was actually very reluctant to do a study about men. I'm a feminist, and the last paper I've done as part of my master's study, the previous one, was about family violence. So I'm very aware of, how prevalent it is in New Zealand, how damaging it is. I didn't want to be the one who's sort of, carrying the flag for men, but I have changed my mind.
Because of some of what
research.
you've seen? Because of some of what you've seen?
Because of some of what I've seen, and mainly because my realization was that the amount of frustration and anger that men experience through the process, through feeling that, the system is biased against them and the system sees them as bad people, whether they've done something or not. That's the general feeling. Now, family violence is, a terrible thing, and the awareness, I think that the awareness of the last few years to the problem, which is a really good and important thing, but in a way it put men in a position where they feel, they describe it at least, like they feel like they're criminals before mediations has even started. They feel that mediators treat them with suspicion. They feel that there's not enough understanding of their point of view.
Can we start with the hard data, and can you explain the suicide rates and the psychiatric hospital admissions figures are dreadful? And are these because the work you've done is qualitative, right, a very small sample,
yep.
But are these figures representative samples when we look at these appalling statistics?
So, the first thing that came very clearly in my interviews with men, and you're right, it was only 13 men that I've interviewed. Qualitative research does tend to be small samples. But the first thing that came up very, very strongly is the strong grief reaction that men have to divorce, much stronger than women's. When I started reading the literature around the world, I discovered that it's not, just the men I've spoken to. It's a worldwide phenomena that men react much more strongly. The statistics I found in articles from around the world, especially from Canada, there's a researcher in Canada that did a lot of work on investigating men after divorce, show that men commit suicide 4.8% more than women after divorce.
4.8 times more, isn't it?
Yes.
Nearly 5 times more likely.
Yes.
Right.
Men are admitted to psychiatric hospitals 9 times more than women following divorce. The rate of car accidents that men are involved with after divorce double from 6 months before the divorce to 6 months after the divorce. Men develop health problems such as cancer, heart attacks and diabetes a lot more following divorce. And so yes, the reaction is very strong. It might have something to do with the fact that the statistic worldwide is that women initiate about 70% of divorce.
What it says is the response, and this is generally, the responses can be quite extreme and very damaging to mental health and to survival, in fact, in some instances. So this comes right to the heart of how a separation and how a divorce happens and how the system cares for people, doesn't it?
Yes, it does. With almost 50% divorce in most Western countries and in New Zealand 40-something%, I don't think our society is really attending to the problems. There's so many men, women and children that have, severe reactions to divorce, and I don't think there's enough that is happening to actually give them support.
Can we talk about what's happening to parenting, a father's parenting throughout this process as well? And again, I'm curious as to whether this disengagement you describe, does this come from your small sample of qualitative research or is it more general? Because you've found this trend that fathers who were very involved with children prior to divorce and had a close relationship would often disengage. Now, again, is that an overall statistic or did that come from your specific work?
No, that's an overall. So all the men I've interviewed were very involved with their children and cared a lot. So
what does the actual representative sampled research tell us about what happens to fathers' engagement with children, fathers who were very engaged and close to their children with the divorce process?
Yeah, so I think, we all know the phenomena of fathers who, following divorce, disappear from their children's life. And, people normally attribute it to men don't care, men don't really, don't want to be involved with their children once the divorce has happened. But then this Canadian researcher, Edward Crook, started investigating the phenomena. And what he found in his studies is that when he interviews disengaged men, absent fathers, what they're called, he found that when he asked them, how were your relationship with the children prior to the divorce, he found that these absent fathers were actually the fathers who were the closest to their children during the marriage. And what he found is that for them to turn from from a full-time father to a visiting father who sees his children maybe once in 2 weeks, takes them out to dinner, is not really involved in the day-to-day care, just broke their heart. And the pain was too strong to endure, and that's why they disengaged.
Let's look at the specific group that you spoke with who were involved in the New Zealand system.
Yep.
Again, qualitative research, we have to stress, it's not a representative sample. However, it's a chance to talk very intensively to a sample. Did you find it hard to find people prepared to talk, by the way, Nurit?
Yes.
Yeah.
Yes, that's why, I was hoping to interview a few more, but men typically, especially with this painful subject, are not too keen to talk about it.
So what was it that you learned from the ones you spoke with in detail?
There's two themes that came up, apart from the really severe reaction. The other two themes, one was the devaluation that our society does to fathers. So men at the moment get a very conflicting message from society. On one hand, they're told that, the new father has to be an involved, warm, engaged father with their children. But the other message is you will never be as important to the children as the mother. The mother is the important parent. You're there, you're important, but you'll never be as important. And they get that from, men hear this message from the mothers who tell them often, oh, you're a shit father, so you're not as important as I am. They get it from mediators who tell them, well, at the end of the day, you have to appreciate that the mother is more important for the children.
Was that actually the experience in the New Zealand system of some of the men you spoke to?
Yes, definitely. And I have to say that today, there's very interesting research coming from Cambridge University at the moment that compared the parenting of gay fathers, gay families with heterosexual couples. And I have to say, I'm sorry if I'm hurting anybody's feeling, but fathers are as good. And even this research found in some aspects fathers are better parents than mothers.
What does all this add up to when you look at how our system works? Because no matter how you look at it, you are dealing at deeply emotionally, intensely emotionally affected people, feeling like they have everything to lose and potentially innately suspicious. I'm talking about those who haven't gone to mediation right and done it well, and plenty too, and been able to do it well. But those who really do feel like they are in a battle for one reason or another, in a very heightened emotional environment with so much at stake. And what is it that our system is or isn't doing to help mitigate and to help navigate to the best solution?
Well, the point, the main thing that we have to remember all the time is that our system, that our law says that the most important thing in this process of separation is the well-being and the best interest of children. The research about children shows that the least amount of damage to children following divorce is when the children continue to have a meaningful relationship with both parents. What's the other bit of information that we know from 40 years of research is that mediation is the best tool to bring people together, to bring parents to be able to cooperate and communicate after divorce so their children are not badly damaged. So what we need to do is to encourage mediation over an adversarial battle in the family court.
If we look at the practicalities of that, Nurit, and Mark might want to come back in here, we ended up with cases bypassing mediation and going straight to the court because people wanted a lawyer, whatever stage of the system they were in. Was that a fatal mistake, Mark?
Well, I think that having a lawyer, I think, was important. I think that basically even just going to mediation, it's hard to go on their own. I mean, the old system where you're with the judge, what people do now, Kathryn, is they have what's called a settlement conference where they can be with a lawyer and do feel kind of safe. I think the big mistake we made, and this was the reason for the 2014 reforms, and I think Nurit's study brings this out, we said these are private matters, and so it's for them to sort it out. Well, while they are private in one sense, there are massive public implications of them in terms of health, well-being of children, well-being of parents, well-being of everyone. And the biggest issue, I think, that comes through all the studies that I've read is that people don't feel they've heard. I mean, I've read lots of the fantastic research on the other side by the Backbone Collective, for example, with women saying that their concerns about the power and control they suffer hasn't been heard by the court. We're now hearing about the men saying they're not being heard. The system really has to slow down a bit and give people a chance and support to be fully heard so they're healing as they go through, and then they can start to do good decisions about their children. Trying to rush them through the system and say, you can sort it out yourself is never going to work when it's the deeply most emotional thing they'll ever face in their life.
Well, it's ended up counterproductive with the extra stresses on the court anyway. So if ever there was a motivation to reduce the role of the court and all the money being spent on lawyers, it's backfired. So do we go back to point A, which is start with counselling even before mediation?
Yeah.
Start with beginning to deal with some of the emotions that Nurit's study and the international research says is causing such harm.
Yes, absolutely. I think we don't do any emotional training in any of our systems, none at school, none at university. I mean, it's the most important thing to control one's emotion, to control one's fears, to control one's anxiety. We all have them, and all of us have our bad days. And when people are going through the high stress of divorce, the emotions are at their peak. So we do need some system whereby people have a chance to kind of work those through their system so they can then stand back and see what can we do here, what's best for our children. Some people have already worked through those as they were breaking up, but others, the breakup triggers that, and they need the time and support to get through that process so they can actually look to the future in a more positive way.
Just a closing sentence, just to, I don't agree with Mark in that respect. I don't think the lawyers are needed in the system. And, counselling is a great thing if it can happen. The family mediation system that was created by the law in 2014 is a good system. But
then
it's
underutilised. Why are people bypassing it, though, Nurit? And the understanding is the reason they're bypassing it is because they want their lawyer. And if they went to a without notice motion, all of a sudden we went from 30% of people cases to 70% of cases going to that without notice procedure because they want their lawyer.
No, I don't think that they want their lawyer necessarily. I think there's a combination of reasons. Maybe some people want a lawyer. Most people after divorce actually have severe financial problems, and they don't necessarily have money to spend on the lawyer, money that will be much better spent on their children. I think lawyers, to an extent, probably encourage them to go to court rather than sending them to mediation. But I think that also, I think the discourse between men, that's where my research comes into the picture. I think the discourse between men that says, mediation is biased against us, they're not going to give you, a really fair treatment there, is one of the reasons. And that's where mediators can probably do, a little bit better in giving more respect to men who come to mediation, reducing the levels of anger and frustration, and then maybe there'll be a little bit more willingness.
Can I have one just last thing? I don't think lawyers do encourage people to go to court. I know most of the family lawyers in this country. I've worked with many of them and taught many of them, and most of them want the parties to resolve it themselves. And it's a very strong message that family lawyers give. And that was one of the misconceptions with the 2014 reforms, that lawyers encourage people to go to court. I mean, lots of people, even before they go to mediation, want to know the legal lie of the land. And so knowing the legal lie of the land, you feel comfortable in the mediation process. Going in blind is very hard for people. The biggest study done on mediation in the UK of 1,000 people said more people like mediation, but they also, more importantly, wanted to have a lawyer beside them. It's a bit like climbing a difficult mountain when you come into divorce. You need someone to say, here, watch out for this, watch out for that, don't go down that path, and get you through it. And that's what most lawyers do if they're doing their job properly.
So where does that leave us with system changes post the review done by Ros Noonan? As I said, 2 years ago that reported. There's been some change. Is there anything on the agenda for more change?
Well, it's not as much as one would have liked, I think, Kathryn. I mean, there is another amendment that's in the law at the moment. It's only a bill at the moment whereby they're encouraging people in the mediation process, which is now called family dispute process, to facilitate children's point of view to come in so that people make better decisions. As Nurit rightly said, it's about the children and they often get forgotten. They may not be physically there. That's been put into the process. And there's also a stronger emphasis on lawyers' duty to encourage their parties to conciliate, to go to mediation. So that's already been in the law, but it's been put in again in the Care of Children Act. It used to only be in one other part of the legislation. So there's small things, but I think we need to give more support. The system, the whole idea of the family court was to have support in the court. We've now privatised it, so it's just become a court. It used to be a court with counselling and all these other things connected to it. So people felt safe in there. Now it's private. The private organisations, I'm sure, are doing a fine job, but it's kind of removed from the court, and I think it's kind of got disconnected.
Being what? Judges in the end don't know what's really happened in mediation. The two are separate processes.
They're meant to be separate processes anyway. Judges should not, anything said in mediation is totally confidential. So judges aren't meant to know that. They should only set that. But judges themselves want to settle these matters. I mean, judges don't want to go to a hearing, because once it goes to a hearing, and I agree with Nurit on this, you have allegations going back and forwards. But there is a process before a hearing, which is kind of like a mediation, where a judge sits down for a settlement conference, hears from both parties, and then discusses with them options, saying, have you tried this? What about that? And so that it's settled in that way without having to go to that wounding thing where people send affidavits back and forth. And once it gets to that, it's very hard to kind of stop at that point.
So where does the judges' settlement conference happen? After mediation is presumed to have failed or only partially succeeded in a result?
Even if mediation succeeds, if people want the order to actually be what's called a consent order, then it will normally be put in front of a judge, and the judge may want to talk to the parties about it to make sure they're happy with it. Because any agreement at mediation isn't strictly enforceable, but a consent order from the court is enforceable if people are worried about enforceability later on.
So when you talk about privatising it, are you referring to who's doing the mediation? What's your concern around that?
Well, I suppose in a sense they used to come to the court and they would have the counselling coordinator. The court provide the kind of therapeutic arm to the court itself. Now, there are different points of view on this. Some people, including family court judges, think having it separate from the court's a good thing because the court's a court. But the court had a wider arm to it, and I think that was a good thing about the family court. It's now gone back to be a court, and it does a pretty good job as a court. But having that therapeutic arm, it was just a one-stop shop. It was a one-stop shop.
It's psychological that this mediation is part of the process I'm in, and the court is there, one out and one back. Whereas now they're the two things. I understand what you're saying, and that is really a psychological difference for potentially stressed people, isn't it? Yeah, and I did a study a few years ago with one of my excellent honours students, and looking at, because there was a concern that judges weren't truly mediators, that judges were really just sort of. But the interesting thing about the study was that, and we went into it with an open mind, majority of people found that having a judge as a mediator gave some sort of finality to them in that sense. In other words, they felt that the judge gave some points of view which were helpful, and some of the judges were superb mediators, in fact. And so that at the end of the day, even though the judge was probably not a trained mediator in the sense that Nurit is speaking about, there was a chance for them to talk about it. They weren't forced to agree to it. They listened to what the judge had to say. And when the judge made some ideas about how it's important to do these things, because the judge had some authority there, they felt, particularly, I mean, not everyone liked the judge mediation. Some judges didn't do as well as others. But when they did do it well, people felt that the judge being there gave it some finality, which meant they could move on with their lives. So it was a reasonably positive outcome of the judge being mediated. Look, thanks both of you for your insights. That's Mark Henaghan speaking there. Thanks also to Nurit Zubery on her research.